Welcome to our Frequently Asked Questions vlog, FAQ Friday. Today I'm joined by guest speaker Erik Vollebregt of Axon Lawyers in Amsterdam. Erik, we received an interesting question for our vlogs on the EU MDR demanding a legal agent for doing clinical trials in Europe. And so we thought it would be interesting to hear from you some details on what legal representation is required by the MDR for what situations, and what the role and responsibilities for these legal representations are.
Hi Gert, nice to be speaking to you about this interesting question. The MDR is indeed, as you could say, the novelty of needing a legal representation for clinical trials. So that's it's an interesting question. The concept of needing a legal representative is, of course, well, we knew that from the medical devices directives already, right? The authorized representative, which was some kind of a legal representation, and actually also we knew from the medical devices directive, for example, that the authorized representative even had some explicit tasks that you could mandate the authorized representative in relation to clinical trials with. So now under the MDR, we have a slightly, let's say, developed situation with the additional legal representative. And this arrived in the MDR because the clinical trials regime in the MDR really was intended to be convergent with the clinical trials regulation for medicines, the one from 2014, which, by the way, is still not in effect, because they have some issues with their database. Sounds completely unfamiliar under the medical devices regulation, right?
No link to Unimed, I realize.
Set up a database by the commission. I mean, what could go wrong, right? But anyway, so this legal representative is also mandatory now under the MDR if you're going to do clinical trials. And it's interesting that because this was invented under the clinical trials regulation, there is also quite a lot of interesting Q&A already available with respect to legal representation, legal representative under the clinical trials regulation. So if you look on the website of the Commission under Lex Volume 10, Clinical Trials, there's a Q&A document from July this year that has a bunch of questions, Q&A, and guidance also on the legal representative, which I think can actually be one-on-one applied to the medical devices regulation legal representative.
And so quite different then from the authorized representative, because that's kind of new. It follows on the old situation, but there you have the liability and some new requirements in MDR. You're saying basically, yes, this is new for the medical device field, but we should learn the lesson on interpretation and implementation from our pharma colleagues that have been doing this for a few years in preparation to it becoming fully functional.
Yeah, you're completely right. And with respect to liability, that's an interesting point, because with respect to authorized representatives, we had the innovation in the MDR that the authorized representative was jointly and severally liable for product liability in case the manufacturer was not compliant. Now, that's different for the legal representative. So even though the legal representative is also a mandated contact point, you could say, for the authorities in Europe, there is no, let's say, similar liability for product liability under the MDR for the legal representative. If the legal representative does contravene its own compliance obligations, however, of course they are liable, and that's also something that the member states have put in their local regulation for sanctions for infringement of the MDR.
So I have one final question then, Erik. So what if a manufacturer makes a mistake and forgets about this legal representation? So a clinical study, say on an existing product, is running.
Right.
Who is then responsible? Is that then the authorized rep? Is that the importer? Is that the hospital, or anyone else? So how is that organized in case of forgotten to appoint someone in this point?
Right. Yeah, so that's a good one because let's say, for example, if I were a CRO, I would be worried about maybe being inadvertently seen as the legal representative, for example. So that's something I understand people worry about, but it's the sponsor's obligation and responsibility to appoint the legal representative. So even if the sponsor neglects to appoint a legal representative, then let's say a CRO or an authorized representative or another party or maybe a subsidiary of the manufacturer that does work in relation to the trial cannot, let's say, just by operation of law, be seen as a legal representative. So you need an explicit mandate for somebody to become a legal representative.
Excellent. So that's good news. You cannot be responsible without having had the choice to accept that responsibility. Yeah, Erik, thank you very much. Go ahead.
Oh yeah, no, I was in full lawyer mode, so I just wanted to make the point that the Q&A under the clinical trials regulation that I refer to also has a neat little shopping list of items that the mandate agreement for the legal representative should contain. So that might also be a good tip for the listeners to this Q&A vlog.
Well, thank you, Erik. Many of our viewers will have once again learned something new on the EU MDR. At least for me, when I first read this part, it was like, oh, I think many more people have not had the attention to this detail. So I really thank you for your contribution, and for all the listeners. If you have any other questions for our Friday vlogs, then let us know either on LinkedIn or website or direct mail. And hopefully we'll have some more to follow up in the future. And once again, Erik, thank you for contributing as a guest speaker.
Very welcome.